Welcome to this explainer. Look, if there is one single thing you take away from our time together today, let it be this. Just because someone does something careless and you end up injured, it absolutely does not mean you automatically get a payout. It's actually far from it. In the eyes of the law, a claim has to survive what I like to call the gauntlet of negligence. You know, you might be able to prove someone had a duty of care, and sure, you might easily prove they breached it. But to actually win a negligence claim, you've got to prove the third and arguably the trickiest element of the whole shebang: damage.
Okay, so here's our roadmap for today's explainer. We're going to cover damage versus damages, the but-for test, breaking the chain, remoteness and foreseeability, and finally, the eggshell skull rule.
Section 1. Damage versus damages.
So in everyday conversation, we toss these words around interchangeably, right? But in law, they are completely different beasts. Damage, without the S, is the actual real-world harm suffered by the claimant. We're talking about the physical injury, the psychiatric trauma, the smashed property, or the financial hit. Meanwhile, damages with an S, well, that's the money. It's the financial compensation awarded by the court at the very end of the line. So the crucial thing to remember is that our focus today is entirely on damage. We're looking strictly at how a claimant proves a defendant's careless behavior actually caused their legally recognized harm.
Section 2. The but-for test. All right, welcome to the first major filter in our gauntlet. I want you to play judge for a second. When a case lands on your desk, the very first question you have to ask is simply, did the breach cause the damage in fact? Because negligence isn't just about punishing people for acting badly. It's about holding them accountable when their bad behavior actually changes the outcome.
To figure that out, courts use a beautifully simple yet incredibly powerful tool. It's called the but-for test. You literally just ask, but for the defendant's breach, would the damage have happened? If the answer is no, like the damage wouldn't have happened without their mistake, then boom, the defendant caused it. But if the answer is yes, meaning the exact same harm was gonna happen anyway, regardless of what the defendant did, then they didn't actually cause it.
Let's look at how this plays out in the real world with the famous 1969 case of Barnett versus Chelsea and Kensington Hospital. 3 night watchmen showed up at the ER feeling incredibly sick after drinking some tea. A nurse called the duty doctor, but the doctor just refused to examine them, basically telling them to go home and see their own physicians. Tragically, it turns out the tea was laced with arsenic, and one of the men died. His widow sued the hospital. Now, the doctor clearly owed a duty, and he obviously breached it by ignoring them. But the claim still failed. Why? Well, medical evidence proved that by the time the men arrived at the hospital, the arsenic poisoning was already so advanced that even with absolutely perfect medical care, the man still would have died. So, applying our test, but for the doctor's failure to examine him, would he still have died? Yes, which means the doctor's terrible behavior didn't actually cause the death.
Section 3. Breaking the chain.
Now, sometimes the defendant definitely starts the dominoes falling, but then things get a little complicated. A completely new, totally unexpected event crashes into the timeline and takes over as the real cause of the damage. The law calls this novus actus interveniens, which is just a very dramatic Latin way of saying a new intervening act. Imagine you slip and bust your leg because someone did a terrible job repairing a staircase. You're in an ambulance rushing to the hospital, but then, bam! The ambulance gets T-boned in a completely separate road accident, and you suffer a severe head injury. The guy who fixed the stairs is definitely on the hook for your leg, but is he responsible for your head injury? The law says no way. Even though you wouldn't have even been in that ambulance but for his bad step, the car crash is a new intervening act. It's so independent and so unexpected that it literally severs the chain of causation. The original negligent guy is let off the hook for that later damage.
Section 4. Remoteness and foreseeability.
This right here is where we cross the border from cold hard science into philosophy and fairness. As we just saw, factual causation asks the scientific question, did your action physically lead to this result? But legal causation asks, is it actually fair to hold you legally responsible for it? The law knows that a single careless act can ripple outwards endlessly, like a stone in a pond. But defendants aren't going to be held liable for every single bizarre, distant butterfly effect of their actions. Some consequences are just too remote.
The absolute foundational case for this is the Wagon Mound from 1961. A ship carelessly leaked fuel oil into Sydney Harbor. The oil drifted over to a nearby wharf where guys were doing some welding. A couple of days later, sparks from the welding ignited the oil, and the resulting fire burned the entire wharf to the ground. The court actually ruled the ship owners were not liable for the fire. Look, spilling oil might foreseeably cause some pollution damage, sure. But back then, fuel oil sitting on cold harbor water wasn't known to just catch fire.
The fire was not reasonably foreseeable, so it was ruled too remote. The golden takeaway here is that a defendant is only liable for damage of a type that was reasonably foreseeable.
But listen, there is a massive caveat here. The courts only care about whether the type of harm was foreseeable, not the exact, freakish scientific sequence of events. Let's compare two cases. In Hughes, workman left an open manhole covered by a tent with hot paraffin lamps. Two kids knocked a lamp down into the hole, causing a massive, freak explosion that badly burned one of the boys. Now, the explosion itself wasn't foreseeable, but the court said, hey, getting burned by a hot lamp left in the street? That definitely was. The type of harm was foreseeable, so the defendant had to pay. Now contrast that with Doughty, where an asbestos lid accidentally fell into a vat of molten liquid. It triggered a completely unknown chemical reaction and exploded. Because science at the time literally didn't know that reaction was even possible, an explosion wasn't a foreseeable type of harm at all.
This whole principle gets reinforced by a 1967 case, Bradford versus Robinson Rentals. An employer forced a driver to take a van out in extreme freezing weather, and the van had no heater and no defrosting. The poor guy had to drive with the windows rolled down just to see the road, and he ended up getting frostbite. Now, frostbite in an English commercial van? That's highly unusual. Nobody would predict that exact specific injury, but the court said it didn't matter. Exposing someone to extreme freezing cold creates a perfectly foreseeable risk of physical injury related to the cold. Because the general kind of harm was foreseeable, the employer was held fully liable.
Section 5. The eggshell skull rule. All right, we've arrived at the final and honestly the most fascinating hurdle. Once you actually pass the foreseeability test, meaning you caused a type of harm that a reasonable person could see coming, the rules suddenly shift dramatically in favor of the claimant. It's driven by this famous legal maxim, take your victim as you find them.
Take the absolutely tragic case of Smith versus Leech Brain. A worker suffered a burn on his lip because of his employer's negligence. Now, a burn in a metalworks factory? Entirely foreseeable. But this specific worker had a dormant precancerous condition. That single, relatively minor burn triggered the condition, caused him to develop full-blown cancer, and he sadly died. The employers tried to argue that death from a tiny lip burn was completely unforeseeable, but the court shut that down. Because the initial type of damage, a burn, was foreseeable, the eggshell skull rule kicks in. You do not get a discount on your liability just because your victim happened to be exceptionally fragile. The defendant was on the hook for the full, fatal extent of the damage.
So, as we wrap up this explainer, let's just step back and look at the whole picture. For any negligence claim to succeed, it has to survive this entire three-step gauntlet. You start with proving a duty of care was breached. Then you've got to prove factual causation, that the breach actually made a real-world difference to the outcome. And finally, you must prove legal causation, that the damage wasn't just some totally bizarre remote butterfly effect. So here is your ultimate checklist. Whenever you're analyzing an accident, ask yourself, did the breach cause the damage in fact using our but-for test? Was the general type of damage reasonably foreseeable, like the burns or the cold injury? Did any totally wild new event crash in and break the chain of causation? And finally, if they are liable, does the eggshell skull rule force them to pay for a much larger extent of damage than they ever possibly imagined? It really leaves us with this incredible, compelling tension right at the heart of our legal system. Depending entirely on exactly who your victim happens to be, or exactly how those dominoes happen to fall, the exact same careless act could get you completely off the hook or put you on the hook for millions. So I want to leave you with this question. Is the law's attempt to balance cold scientific fact with philosophical fairness actually fair? Or is negligence just an incredibly high-stakes game of roulette? Thanks so much for running this gauntlet with me today. Keep asking great questions, and I'll catch you in the next explainer.